good evening to all the attendees to this new event organized by the Iberian chapter of the Chartered Institute of Arbitrators. This time, together with the United Arab Emirates Branch of in our institution. Today is October 19th, 2022, and it is 5 p.m. CE time, speaking me from Madrid at this very moment. I'm Antonia Musategui Batalla, and I'm here today in my position of chair of the Iberian chapter within the European branch, which is going to host this event. This event is the ninth in our events program of this year 2022, and it's the first since the third since constituted as Iberian chapter, joining our colleagues in Portugal and Andorra, together with our peers with presence in Spain. And especially today, we are going to have, from the first time, a ride outside from our natural borders, either local or regional. We are going to talk with our colleagues in the Middle East. For such commitment, we arranged with the United Arab Emirates Branch, thanks to Natalia Barroso, which is a fellow member of our Iberian chapter. And we are going to talk about common grounds and explore possible bridges addressing both the directions, here and there. I have to say that among the environmental members here, we have the presence of Irina Akulenka, who is now the former chair of the United Arab Emirates branch of Ciarb. I would like to have her special recognition for helping this event as to become real. Irina, please receive my special gratitude and pleasure for having this done possible.
Thank you very much, Antonio. It's a pleasure to be here, of course. Good evening, everyone, or good afternoon, good morning, depending on your time zone. Thank you all for joining us today for this event. I just wanted to say that on behalf of the UAE branch, we are always keen to collaborate with other branches and chapters. So thank you for this opportunity to join forces for this event today.
My pleasure, Irina, for having you here together with Robert Silwinski, and the rest of the people connected to the UAE branch of the Institute. We are very excited about the achievement with this event for our members in the chapter, but not only. I would like to talk about something else, but in order to proceed with ease, I will stop talking and let my colleague Natalia Barroso, which will pilot the conversation in her role of conductor. She will explain some tips before proceeding with the program. Natalia, please take the route in this sailing route.
Thank you, Antonio. It is a pleasure to take part in this conversation as member of the Ciarb UAE branch, but also as member of the Ciarb Iberian chapter, and thus be the link between the two regions. I will be moderating today's discussion, which is scheduled to last 1.5 hours and will be divided in one part that will consist in 5 issues that will be discussed with our panelists. The first of these 5 issues is going to be the Dubai International Arbitration Center, after the Decree 34 and the new DIAC arbitration rules, but also we will comment on the overall development of the ADR in the UAE. Following to this, we will go to the next topic, which touch on the judicial arbitral collaboration between the Emirate courts and the DIAC, with regards to provisional measure, discovery and evidence, examination, and award execution. Next, we will talk about the civil common law principles, uncidental rules, and Sharia law principles. And then we will delve into the influence of the Ciarb members across the United Arab Emirates, and we will cover as well training and education skills within the Ciarb principles in UAE, as well as from the Iberian side. Before I introduce our panelists, I will briefly go over a few housekeeping rules. The first is that as per registration information, this event is going to be recorded and transcribed. So if you have any, you can use the chat button just for general discussion, and if you have any technical problem. And now let me introduce today's panelists. First, we have Irina Kulenka, who is the former chair of the Ciarb UAE branch, and she's an associate director with HKA Dubai. Irina specializes in contracts and quantum, assisting clients in any facet of contractual disputes in the infrastructure, construction, oil and gas, and energy sector. Welcome, Irina, and thanks for joining us today. Then we have Robert Levinsky, who is the current chair of the Ciarb UAE branch. He's a practicing barrister, chartered arbitrator, accredited adjudicator and mediator, quantity surveyor, and dispute board member. Robert has over 35 years experience of the construction industry, with particular emphasis on all forms of alternative dispute resolution. Welcome, Robert. Nice to see you today.
Thank you very much.
Okay, now we will have Nazaré Romero, so maybe she's going to be a little bit late, but she will come here to the discussion. And Nazaré Romero is partner at Oboli Frugioni Romero. She's head of arbitration and alternative dispute resolution, specializing in commercial and investment arbitration. She's professor of arbitration, alternative dispute resolution, law and economics, and international law. And also she's arbitrator and TSD expert European Commission and civil expert external European Commission, DG Justice and Home Affairs. She's also co-founder of Iberian chapter with Antonio and member of the committee board EU branch Ciarb. Okay, so she's not here, but she will join shortly. Then we have Pavel Kaleb, who is senior case manager with the Dubai International Arbitration Center. Prior to joining DIAC teams in 2018, he worked as an attorney at law in his home jurisdiction, Bulgaria, followed by 3 years tenure at a Dubai-based law firm, specializing in commercial matters with a focus on contracts and arbitration. Apart from his day-to-day managing arbitration cases, at present Pavel actively contributes to the digital transformation of the DIAC by developing its e-case management system, as well as to the overall growth of the center by developing rules, policies, and procedures. Pavel was a core member of the task force which drafted the new DIAC arbitration rules 2022. Welcome, Pavel.
Thank you. Glad to be here.
Also, we will have today with us Sankarim KC. Sheikh Mohammed Samuel Karim is a specialist in domestic and international commercial arbitration. He's a member of the Charter Institute for Arbitrators and is admitted as a practitioner in the DIFC and the ADGM. He acts as counsel and more so recently sits as a panel or sole arbitrator. He speaks throughout the world on international arbitration, including recently the IBA and GAR Dubai, Abu Dhabi and Paris, and Legal 500 London. Sam is the editor of Karim on international arbitration, the global guide practitioner to be published this year by Elgar, and is also published in the area of AE and arbitration and Islamic finance. Sam also is a panel arbitrator for the ADGM and the International Islamic Center for Reconciliation. So once we have introduced our panelists, I will be starting the first question. So the first question is, where does the DIAC stand now from a local and international arbitration standpoint 1 year after the Decree 34 and the publication of the new DIAC arbitration rules published March 2022? And also, what is your take on the overall development of the ADR in the UAE?
So thank you, Natalia, and thank you for having me in this webinar. So I will start as a general comment regarding the development of the ADR in the region. In the past few years, we can see a significant growth from before. Of course, it was the ADR was developed in the region and the UAE, particularly from before, but it was never codified. The rules for the arbitration were never codified on federal level. Everything what was about arbitration in the UAE was to be found in several provisions in the civil code. However, due to the growth of investments in the UAE, the mega projects, always in Dubai and Abu Dhabi, you can see in the news, there are always ongoing mega projects and construction overall. I've read somewhere that 70% of the cranes in the world are in Dubai. So that is why the government took action, and since 2018, we have a new UAE arbitration law, which is based on UNICITRAL rules, which further boosted the development of the ADR in the region and reflected the increasing offering of all the centers in the UAE. Predominantly, it's arbitration which is covered in the UAE. However, recently also mediation is having growth, which was reflected in 2021. Again, there was a federal law issued on mediation, although it deals mostly with court administered mediation. It shows the path that the government recognizes the growth of ADR in the region. And I, don't want to brag, but all of this, especially in the UAE, was predominantly due to DIAC's success, not only locally, but regionally, and also somewhat internationally. So DIAC, to come to your question, to the specific topic, DIAC, as a background, as a history, was first created in 1994 as an initiative by the Dubai Chamber of Commerce and Industry. It was then dealing with construction disputes for the members of the Dubai Chamber. However, due to its success, especially as I've said, all of the constructions in Dubai result, unfortunately, in many disputes. It was decided to establish DIAC as a separate center in 2004 by decree of the Sheikh of the Dubai. And since then, we're the largest center in the Middle East. And if you allow me, I will now share the statistics of DIAC. Sure. I hope I will not be boring. So as you can see, since 2016, we have more than 1,500 cases registered. Mm-hmm. However, this statistic does not show the full accomplishments of DIAC because around the previous financial crisis in 2010, we had spike of cases, mostly around 2010, 2011. We had more than 450 cases. So again, now you can see that there is a spike because of the aftermath of Corona, which resulted in a lot of disputes. Parties, now we notice that they are trying to settle a lot of them, but still the disputes increased in the past 2 years. Mostly, again, as I said, DIAC was established to deal with construction disputes. So even now, most of the DIAC cases are either construction or construction related, because real estate cases are also closely related to the construction field. Nationality of the parties, although this graph shows that there are not so much foreign disputes, in reality, most of the disputes are actually between UAE incorporated companies, but most of them are actually with international ownership. So I can say that almost all of the DIAC's disputes that we administer are with a very high international element. As to the value of the disputes, again, since 2016, the average value is 4 billion. Again, as I said, you can see that in 2021, because as the results of Corona, the parties were trying to settle all of most of their disputes. So the average value for the 2021 is really low. However, this year we are compensating, because now the parties, most of which were not able to settle or now have fresh funds to start arbitrations, have initiated big cases. And as for nationality of arbitrators, although we don't have, when we do direct appointments, any preferences, but usually the parties are preferring to nominate arbitrators which are experienced in the region. So that's why they're choosing usually arbitrators which are based in the MENA region. Also, as to direct appointments by the DIAC, especially before the UAE arbitration law was implemented, as you may know, all the hearings should have been done in the seat of the arbitration. Even the award should have been signed in the seat of the arbitration, and that is why we appointed many locally residing arbitrators in order to save costs for the parties. However, now this graph, I am sure that it will change, because now our hands are untied and we can appoint many arbitrators from abroad, because now, you know, one of the good outcomes of the Corona was that it really increased and gave a kick for the online proceedings, hearings, everything is done online. So this will also increase our international participation of arbitrators. And as for the future of DIAC, again, as you said, just stop share. Our major achievement in the past 1 year is the DIAC Arbitration Rules 2022. As you said in my introduction, I was part of the task force which drafted the rules. However, I will let someone else speak about them, because from my point of view, I can always say something good, but we are open to criticism, of course, in order to revise them and to be better in the future. Also regarding mediation, we're now finalizing the mediation rules of DIAC, which we hope to be out by the end of the year or in the beginning of next one. Yeah, we're trying now, we're focusing, of course, on our local presence, but we are increasing our international presence, which we are also ordered to be in the top arbitration centers in the world by the decree of the Sheikh.
Yeah.
So this is what the future holds for us.
Okay, thank you very much, Pavel. Antonio, so what can you say about, for example, the changes in the Iberian region? For example, you know, the new Centro Internacional de Arbitrajes de Madrid, and also the changes in the creation of this arbitration center.
Yeah, sorry. I forgot to open my microphone. Well, first, in our chapter, we run with 3 jurisdictions, which are Portugal, Spain, and Andorra. Every of these places, every of these jurisdictions have 1 or more institutional arbitrators in centers. I remind, in Portugal, the Câmara Comercial de Lisboa, similarly, the one of Porto, and they both are joining right now together to, or trying to join somehow together in a single one. By the side of Andorra exists since very few years the TAPA, Tribunal Arbitral del Principado de Andorra, which is becoming first steps in this regards. I'm not talking about tradition in arbitral as arbitral tribunal in Andorra, but I'm talking about international arbitration settled in Andorra, and precisely with a kind of future in case of achieving achieving an agreement with the European Union to when Andorra, in case, would enter as member, or whatever they decided, as member, a new member of the European Union. Finally, the Spain jurisdiction have several institutions regarding international arbitration. The Madrid Court of Arbitration is, as to say, it's a sort of joint venture between different institutions, most of them settled in Madrid. I mean, the CEIM, Results of Unity, the International Activity of the Arbitration Court of Madrid, the Civil and Commercial Arbitration Court, the Spanish Arbitration Court, and the Madrid Bar Association. This last as a strategic partner, and not only an arbitration court. The partners in the International Center of Arbitration in Madrid brings together the experience and efforts in order to offer users and partners an independent, transparent, and efficient dispute resolution service internationally. The centers are focused on, the Ciarb, as focused only in administered international arbitration that derive from arbitration clauses that appoint to the center and as the administering institution, and arbitration clauses that appoint any of the 4 boosted institutions as the administering institution. I mean, if, for instance, if the arbitration court, the Civil and Commercial Arbitration Court, according to the agreements, have the mandate to manage an international arbitration, this court derive to the CEIM to effectively administrate the arbitration. There's another institutions settled in Spain as the Tribunal Arbitral de Barcelona, which is not part of the Ciarb, but develops similar activities as the partners from the Ciarb. About the Court of Arbitration, Ciarb was created. The last one I mentioned was settled in Barcelona, precisely. The Court of Arbitration, Ciarb, was created in 1919 and joined the services provided by the Madrid Bar Association as an alternative way to the courts to resolve disputes submitted to aid both in natural and legal persons in matters of their own free will provision. Renewing its list of arbitration in 2018, and grouping by specialists, the impulse given by the governing board headed by the DIAN, Jose Maria Alonso, stems from the full conviction that its members of recognized national and international prestige will help make the arbitration not only fully known and recognized means, but as an effective method that can constitute one solution more to the state of saturation in which the justice finds itself. Nowadays, last month, the court or the center, the International Court Center of Arbitration, International Arbitration in Madrid, has suffered a change in the presidency. Now the chair will become a new person, not Jose Maria Alonso, still not nominated, still not designated, appointed.
Antonio, that's right. And what about it seems that in Madrid as well, or in Spain, they are developing as well some mediation rules, as well as in the...
Yeah. No, but it's related to mediation, in short. Well, it is still a project of law which should be approved by the Parliament this fall season.
Okay, perfect. And Sam, do you want to add anything to the arbitration rules?
Yeah, just very briefly. I think Pavel mentioned the new rules that were promulgated, I think, on the 21st of March. I think congratulations are in order for producing some really good internationally recognized rules now for DIAC. I think the key highlights that we need to just cover very briefly are that now the default seat for proceedings will be the DIFC in the absence of agreement of the parties, and unless the tribunal determines otherwise. There's now a provision for recovery of legal costs, which there wasn't before. There's a possibility of consolidation and joinder of proceedings, especially after the appointment of the tribunal. And there's provision for the interim measures and an emergency arbitrator procedure as well. And allied to that is the provision for expedited proceedings and the establishment of a DIAC Arbitration Court, which supervises the case managers by DIAC. So I think just going back to your original question, I think Decree 34 was a seismic change, but I think things are being done to improve the arbitration in the region and the reputation. And just to finally emphasize that, as Pavel did before, that mediation is growing traction in the region, as you might expect. And there's a new federal law, which Pavel mentioned as well in 2021, which establishes the center of mediation. And finally, I think it's worth mentioning that the Ministry of Justice, the UAE Ministry of Justice, in September this year, issued a letter to the Dubai courts confirming that the Dubai courts may now enforce judgments automatically from English courts. There's a few things you need to do, but it's an important step, as it kind of provides major increased levels of confidence for UK-based investors who are looking to enforce judgments from UK courts or arbitral awards. So that's all really I wanted to say on the DIAC rules.
Okay, perfect. That's very interesting. And as well, it's although it's quite different, there could be that there are like certain similarities with the Iberian region, for example, and we comment on the Centro Internacional de Arbitrajes de Madrid, that was the merge of a number of arbitration center, and also the development of the mediation law in Spain, that also could have some similarities with UAE. So now, if we move to the next topic, I would like to ask to the panelists about judicial and arbitral collaboration in provisional measures, dispute and evidence examination, and award execution. What kind of collaboration do the Emirati courts provide in these three cases? What kind of provision in the DIAC statutes can we manage in this regard?
sorry, was that an open question?
Yes, okay, it's just the judicial and arbitral collaboration in provisional measure, discovery, and evidence examination and award execution in the DIAC.
Indeed, well, certainly here in the UAE, it's clear that certainly with the new rules at DIAC, that all these issues of judicial arbitral collaboration have been addressed, or are being addressed, to be fair, with the courts now being more willing, the onshore courts more willing to work with arbitration and promote arbitration. Of course, DIFC courts and the ATGM courts, being common law, were in any event supportive of arbitration. And I think it's also true that the Dubai courts were supportive of arbitration, but perhaps because there was a difference in process, the civil law process, as opposed to the common law process, sometimes that didn't translate through, certainly to enforcement and indeed support of arbitration. As I'm sure those in the UAE know, but maybe not so those outside the UAE, there are many jurisdictional objections in the local courts based on questions such as, did the person who entered into the arbitral agreement actually have the authorities to enter into that agreement, which is a little different perhaps to the way it's seen in many Western countries, where you have an arbitral agreement within the contract, and so long as the contract has been signed by an authorized member of the company, for example, that's absolutely fine. In the UAE, it's different. You do need specific authority to enter into an arbitral agreement. So those sorts of issues are being more fully understood, and hopefully some of these objections will fade away. But with regards to discovery and evidence, the common law situation is quite clear in the rules with discovery, but not completely open-ended discovery. It has to be reasonable. And I think the new DIAC rules take that into account. And of course, one can use the IBA rules on taking evidence as well. So all of these issues are, I think, helpful to arbitration in the region.
And also, if I may add something regarding the collaboration with the courts, now the Dubai courts actually have a very important function after Decree 34, because as you know, one of the consequences of the decree was that the other two arbitration centers in Dubai were abolished and merged into DIAC, and according to the same decree, DIAC is now administering cases which have referrals in their arbitration agreements to the DIFC-LCIA and to the Emirates Maritime Arbitration Center. So, as expected, many parties are now trying to find another ground to challenge their awards. Since still we don't have such instances, but sure they will follow. So at the end of the day, it's the courts, how to say, it's important how the courts will address this issue, because they will be faced with the parties trying to set aside their awards. So the implementation of the decree is actually in their hands, and they have the duty now to help the good implementation of the decree, because if they create a practice that the awards will be set aside, it will create a big issue as a consequence from the Decree 34. And on the also on the provisional measures, as Sam mentioned, one of the novelties in the new DIAC rules is the emergency arbitrator. So also we're now, since the implementation of the rules, we had three really interesting cases for emergency interim relief. And we are now also waiting for the courts to see how they will test, how this rule will be tested with the courts. And we hope also that they will support the DIAC rules by adopting our vision on the emergency arbitrator figure.
Indeed, I think it's probably worth mentioning, Pavel, as well, isn't it, that the Decree 34, by merging the arbitral institutions within Dubai, has also stated that those arbitration rules, the old DIAC LCIA arbitration rules, if you have that in your agreement, you will in fact be able to use the new DIAC rules. Now, I think in the UAE, that's not going to be a problem because the courts are undoubtedly going to take notice of the decree. There has been comment, would that be enforceable outside of the UAE? But I think it's probably, I think it probably will be, because I'm just trying to think which case it was. There was a French case not so long back when Arbitral Institution Centre had ceased to exist. And the French courts found that the rules that were in the arbitration agreement were still valid, and the arbitral agreement was still valid, rather. And I think that's quite important, that it doesn't simply disappear and those arbitration agreements evaporate in some way.
Okay, perfect. Sam, would you like to add anything?
Yeah, I think Pavel and Robert have covered most of it, but I think if you look at it clinically with the UAE federal law, then you know, the provisions are there in theory for there to be quite significant collaboration, in particular in respect of provisional measures, discovery, and evidence. I think that in reality, the collaboration isn't as great as what we would like it to be, mainly because I think we have to remember that the Emirati courts are a civil law jurisdiction, and a lot of these arbitral rules are slightly different. But I think time will be the best solution. I think as time goes on, the collaboration is slightly better, and in some cases, not. And some of our viewers may know that in a recent case, one of the Dubai courts refused to recognize a arbitral award because it hadn't been signed on every single page, and that's something which has been consistently a problem for a decade now, and consistently most Dubai courts UAE courts have recognized that you don't have to sign every single page as a requirement, but then sometimes you get an anomaly in the system. So I think time will establish a good norm to allow proper collaboration, but the building blocks are there.
Thank you. Another question inside this one is, what effects can the SCOTUS judgment of June 13 have on the access of foreign or international courts to the US discovery by using of the US judicial system help in the experience from the DIAC?
Sorry, could you repeat, Natalia?
Yeah, you know that the effects of the SCOTUS, the judgment of the June 13, have on the access of foreign or international courts to the US discovery by using of the US judicial system help in the experience of the DIAC.
So until now, because as you remember in the preliminary talks, we discussed that DIAC is not per se involved in this. The DIAC rules, they created a frame for the evidences and the discovery, but we don't, as the institution, have any involvement in this process. So I guess that someone of the practicing colleagues on the panel could have a better input on this.
Okay, perfect. Thank you very much. So that has been quite interesting. And now we move to the next question. Okay, now we move to civil common law principles UNCITRAL rules and Sharia law principles. Are these expected to have a fruitful performance in the Emirates international arbitral practice? Have the Sharia law regulation and Islamic finance principles, if at all, influenced the ordinary type of processes?
Yeah, I mean, I'll start off, shall I, on this topic. I think when it comes to the UAE, a lot of people who start practicing there and in fact move there as lawyers think, well, you know, especially when you're in the DIFC, which is a common law jurisdiction, how does this fit with Sharia law? And this briefly, I just wanted to make 4 points. Sharia law is a source of UAE law, but not the only source, is the first point. Where UAE law contains a specific provision, the UAE courts will give effect to that provision, is the second point. The third point is that a UAE court will pass judgment according to Sharia in the absence of provision of UAE law covering the issue to be determined. So in the absence of UAE law saying something, it will revert to Sharia. And finally, that UAE courts will rely on principles of Islamic jurisprudence in the construction and interpretation of UAE law. So I'm not going to speak about the kind of details of and fundaments of UAE law and Sharia law today, but Sharia law consists of what you get from the Holy Book, which is the Quran, and from Sunnah, which is what the Prophet had said. So, so you then may ask the question, well, how does Sharia law end up being a source of UAE law? Well, the starting point is the constitution of the UAE, which was established in July 1971. Article 7 of the constitution provides, in translation, and there are various translations, but it says that Islam is the original official religion of the federation and Islamic Sharia is the main source of that legislation. Note, I think this is important to note, that the article says the main source, and it's a main source, but not the sole source. So it can be the principal one, but not the only one. And that's bolstered by the fact that if you look at the cases in the UAE courts, it regularly gives effect to contractual provisions, for instance, for the payment of interest, notwithstanding the fact that under Sharia law proper, the charging of interest is haram or forbidden. And also that the UAE Civil Code expressly provides that a judge is to pass judgment according to Islamic Sharia law when there is no provision, and I quote, and this is a translation again, no provision in the Civil Code covering the issue to be determined. So where there is an express provision, and this is the fundamental point of the Civil Code, or any other codified piece of applicable legislation, the Federal Supreme Court has settled on the principle that such provision or legislation is presumed to be in accordance with Sharia law. So that then brings us finally to the UAE Civil Code, and that's issued under the Federal Law of 1985. Each of the first 3 articles of the Civil Code contain important provisions about the role of Sharia in the UAE civil legal system. Article 1 of the code provides, first of all, if the judge has no provision in this law, he has to pass judgment according to Islamic Sharia law, again, the presumption. Article 1 also gives guidance in terms of other cases, but Article 2 provides, in translation, that the rules and the principles of Islamic jurisprudence shall be relied on in understanding, constructing, and interpreting these provisions. And Article 3 also gives provision in terms of what to do in public order cases or other related cases. But the point I think I wanted to make, having considered the Constitution and the UAE Civil Code, is that first of all, that the Islamic Sharia is a source of UAE law. There's no doubt about that, but it's not the only source. Where UAE law contains a specific provision, then the courts give effect to that rather than Sharia. And the UAE court can pass judgment according to Sharia in the absence of a provision of UAE law. That's the second point, but put in a different way. And finally, that the UAE courts can rely on principles of Islamic jurisprudence in the construction and interpretation of UAE law. So even if the UAE law, if it says something, the interpretation and construction of that can be considered under the principles of Islamic jurisprudence. So that's something to be aware of. So I think that's all I really wanted to say about the framework of the of Sharia law in the UAE at this stage, anyway.
And if I may add, so the effect of Sharia on the arbitral proceedings, on the procedural rules, I mean, like we discussed before, Sharia rules, they, and also as some, of course, said, they apply mostly on the substance of the dispute, on the substantive law, but on the procedural law, and including on the DIAC rules in this situation, there is no effect. And like we discussed as an interesting fact, Sharia law actually affects the procedures under the Saudi Arabia procedural laws, where the arbitrators by law should be versed in Sharia proceedings. But in Dubai, with the DIAC, there is no such requirement.
I think it's probably also worth pointing out that that the difference between civil law principles and common law principles in arbitration probably aren't that important in reality. Pavel, you can probably correct me. But I haven't seen, in my time here in the UAE, any arbitrations that have been run under civil law procedure, which, you know, they could adopt, of course, the Prague rules, for example, in evidence taking, so on and so forth. But most are, in fact, run on common law principles, despite the fact you're actually utilizing civil law, UAE law. So as far as the practical side is concerned, I don't think there's a major problem. But of course, Pavel, you can tell me if I'm wrong there, just how many arbitrations have been undertaken based on civil law procedure.
So Robert, I could say that it mostly depends on the arbitrators, because if the arbitrators are common law lawyers, they usually steer the arbitration into this direction to follow the common law procedures. If of course, considering the governing law and the seat of arbitration, but if it's like almost all of our arbitrations UAE seated, it depends on the arbitrator, because if the arbitrator, as I said, is civil law qualified, they usually follow the civil law procedure after consultation with the parties. And if it's a UK lawyer, they follow usually the common law.
That's interesting. I'm actually involved in an arbitration at the moment as counsel, where the tribunal are 3 Emirati lawyers, and we are running under the common law principles. So that's interesting. Thank you.
Yeah. I think I've done one in the last 10 years.
Antonio, do you want to add anything? I think Antonio is mute. So can you hear me, Antonio? Okay.
Yes, Natalia, I can hear you now. There's not much to add to this. In fact, here in the Iberian chapter, we have very few experience about what application of Sharia law means for us. I could mention that regarding the SCOTUS decision of June 13, the interesting issue we commented in the past. In fact, we had an event talking about the sentence this last June. What we commented it was how interested the result, the specification from the SCOTUS about the nature of the tribunal, of the foreign tribunal, or the arbitral tribunal, referring the private versus public or institutional nature. I mean, if the tribunal has a kind of touch with sovereignty, this court or tribunal would not have many troubles as to ask for this claim and for collaboration to the judicial system. But if the court, international court, or the tribunal was not related to sovereignty, there should be a kind of barriers to elevate in such a case. Any form. I suppose that these controversial issues is as to ask for help to the American or the US judicial system should be mitigated. I'm not at this very moment known about experiences regarding such kind of request for private court to the judicial arbitral system after the decision of the SCOTUS. And I would like to know if you have any, or in the step of having to request a kind of assistance from the US jurisdiction, federal jurisdictions, as to comment about if you have similar queries in this regard. That is, I know that Nazareth, which she has not yet come, have several notes regarding the issues about experiences in the Iberian courts, but I prefer not to manage because they are so drafted as to not to say something she eventually would not like to say. And that's it. I don't know if referring my last comment before about Nazareth's notes, you have any sort of idea or comment to say about the SCOTUS, I mean, and the sovereignty nature of the tribunal which demand help from the US authorities, judicial authorities. Have no any. If no,
do you have anyone at anything about the SCOTUS case, or it's fine?
Oh, okay.
No, it's okay. So thank you very much for your comments in the SCOTUS case, and as well in the clarifying the Sharia law and the implication of Sharia law in arbitration here in Dubai. And then now we are going to move to the next part that we will talk about the presence of the Ciarb members here in UAE, and also which is is the UAE branch increasing its influence in the region? Who would like to answer this question? Irina, please.
Let me start, I think. Thank you, Natalia. Look, I think historically speaking, the UAE branch has been one of the biggest branches in the world and one of the most strategic branches in the region here. It's been very influential. I'm pleased to say that year on year, we have a steady growth of our membership base. So as of 4th of October, so just earlier this month, we now have a total of 936 active members, that's not including the lapsed members, across all grades, which is up from the previous figure of 924 as of last month, 6th September. So again, this is an all-time high for the branch. A total number for the membership is now 1,038 members, and that includes 102 student members. And in terms of the diversity of our members, most of you would know that the UAE is pretty much an expat community, and we really have a very diverse membership base here. So many of our members, myself included, we we come from Europe, and we make UAE our second home, I should say. So yeah, we have obviously people from Spain, and I'm sure from other parts of Europe as well. In terms of the influence in the region, look, I think suffice to say that still many branches in the region come to us for holding events together. And of course, in the Saudi Arabia, the ADR community is very active now. It's a growing ADR community there. The Institute is also very active recently in Oman. So I gathered there will be a lot of joint initiatives and cross collaboration coming out of these new markets. And with the recent establishment of the new branch in Pakistan, I should say that many of our tutors and approved faculty members are now on sort of a mission to train ADR professionals and judiciary as well in Pakistan. So obviously providing training and skill building for arbitrators, mediators, and other neutrals alike.
That's very interesting. And Antonio, would you like to add this kind of number from the Iberian side?
Right, from the Iberian side. Well, first of all, we are not a branch, we are a chapter. So then some of our functions resides in are settled on the European branch. Any form. Talking about the Iberian chapter, we have here about 130 members of kind. Most of them are members. Nearly a third are fellows, and a very few students. Associates. We are here being only the Spanish chapter since 2 years ago. We expand our local area to Portugal and Andorra in 2021. So then almost a year, first year, this November, being the Iberian chapter. In this time, we're having screening our members. The interesting point resides in two things. First, many of them, almost another third, comes with a profile of STEMs, I mean, science, technician, engineers, and mathematicians, mostly engineers and architects, being members of the art, and many of them about the media from the members are fellows instead of just members. This is interesting characteristic for the STEM profile in a European, in Iberian chapter memberships. The other, what will we do in the last year? We started trying to join together and strengthening the linkages about our members, setting up an intense program of events. In fact, for this first year, we have been organizing and giving in different scopes of activity related with ADR, 10, scheduled 12 events this year. And we are already preparing a program for the next one, for the 2023, with just in the pipeline 4 events for the coming year. Our expectations is to increase by the side of members and by the side of associates. And in particular, associates is something in which we would like to see as to precisely provoke in professionals involved with ADR to continue in the industry, later becoming to the different sorts of specializations given by the SCF, first members and later fellows. Naturally, the last one depends on the interest of each of the members on caring about their own professional profile. Being just 1-2 years, depending on which kind of chapter you ask about, our presence in institutional arbitration as being members is not very low, but despite of this, relevant names in the industry are already members of Ciarb. Not as much as we should desire, but not as many people think. And in this topic, this is what I would like to say. Natalia.
Thank you, Antonio. And Irina, there is a question that someone is asking in the chat, and the question and answer chat, and they are asking that there is the understanding of that there is no Ciarb branch in KSA. Is that correct?
I'm not aware of any law that prevents from having a branch, and I think that's going to happen quite soon.
Okay, okay, perfect.
Yes,
Okay,
in fact, there is a cooperation between the SCCA and Chartered Institute of Arbitrators in training arbitrators in Saudi Arabia. So I'd be surprised if they weren't pushing to have at least a chapter to start with.
Okay, thank you very much. Thank you, Irina, Antonio, and Robert for your comments. And as well, yeah, it's true that here in UAE there are a lot of people here that most of them are expats. Also, like myself, like I'm Spanish. Okay, so yeah, that is true. Okay, so then now we move to the last question, and now we move to the Ciarb, but related to training and education. Have you pushed for new members or upgrading members levels in any training program?
I guess that's a question for me, Natalia.
Yeah.
Yeah, so yes, we have a very active education and training team. It is led by our education and training officer, Kasia Holiday. I'm pleased to say that we run all of the courses from introduction to international arbitration through to module 3, which is the award writing. We also hold peer interviews to help people qualify for a fellowship. And we do run accelerated routes to membership and fellowship as well. So across the sort of international arbitration, we run all of the courses there is. In mediation, we tend to run typically module 1, but I think I'm very hopeful for the future of mediation, and I think that the offering is going to be definitely expanded soon enough in terms of what we are offering training-wise. Pleased to say that from this year, we are offering or starting to offer courses in the Arabic language. For now, it is only for the introduction course, but again, hopefully that's going to be expanded soon enough. Typically, the most attended courses, let's say, is the entry level, which is the introduction course, and the module 1, which is the arbitration practice and procedure. Those are typically well attended. So from memory, I think this year we've had about 15 students on each of those. And we do get majority of our members at associate and membership and member level, sorry. In terms of the collaboration with local universities and educational bodies, we do that. There is British University in Dubai that we tend to collaborate a lot with. Also Middlesex University. The program that's offered by British University in Dubai is a master's program in construction law and dispute resolution, and that's one that is accredited by the institute, and if successfully completed, it provides exemption up to member level for the students that completed that. From this year as well, we are working together on a MOOC with British University in Dubai. So hopefully that's going to take place very soon. We are about to finalize the case scenario. That's first MOOC that's ever been done by the branch here. So again, we are proud of this, and the scenario is very interesting. So watch the space, I think. In terms of training partnerships, we are always keen to enter into, and we encourage training partnerships. And again, at the moment, we are in discussion with DIAC on one of those joint training programs.
Okay, that's very interesting. Okay, there is another question. There is one question in the chat that someone is asking that some member of the Ciarb, however, in his region or her region, doesn't organize any commercial any education. So which would be your recommendation if someone is in a region that the Ciarb there does not organize any training? What would you do?
Shall I answer that one? The Ciarb does, of course, have training for its various levels of membership, and which the whole idea of the membership is to, first of all, get people an understanding of arbitration and, of course, mediation and adjudication in ADR. In some ways, it may have been better if it was called the Chartered Institute of ADR, but we are the arbitrators. But of course, it's to take you through to fellowship, so you have a more than just a good understanding of arbitration. And then, of course, if you're an experienced arbitrator, become a chartered arbitrator. Now, to train for these, there are modules 1 to 4, is it 4 now? Certainly 3, for each level of training towards arbitration. And so what do you mean by organizing international commercial education camps? I'm not sure what exactly you mean by that, but that's something that, because the Institute is a worldwide organization, how would you do that? They do run online courses as well as in-person courses, and the branches also run their own courses. So it should actually mop up everybody who wishes to be trained. So at the moment, HQ, to my understanding, isn't thinking of international camps, arbitration camps educationally, because at the moment their system is felt to cater for everybody who wishes to train as an arbitrator or be interested in arbitration. I hope that answers the question.
Yeah, if I can also add, thank you, Robert. Just from my side, the person who asked this question, please feel free to get in touch with me, and I will connect you with our education and training officer. So if there is any specific courses that you are interested in, we're happy to guide you there.
Antonio, would you like to add anything in training, about training? Antonio, you are mute. Okay.
Yeah. Have to add very few in regard of the Irene and Robert suggestions. The point with Iberian chapter is not allowed, because it's not one of its duties, to organize courses. In fact, this is something to credit and organize courses connected with universities, business schools, or whatever other institutions in reference to ADR or arbitration, especially international. It depends on our branch, I mean, the European branch. And precisely, the European branch will have to get a kind of decision on how to organize such kind of courses. We are in the European branch, there are only 2 credited universities to provide courses in reference to accrediting as Ciarb members. And these both attend to becoming precisely as members, not as associates, lower level, and not as fellows, which is delegated to, from our perspective, delegated to being organized by our headquarters in London. Saying this, I would like to ask to the branch, our branch, if enables us to organize or guide local institutions as to request from them about their interest in credited associates. But this is a work in progress. It's not actually can we do that. And to be frank, we can only say or suggest to the people interested of becoming associates to ask to London or become as to London according to the different pathways that are approved in the Ciarb website, or as to member, to credit it as member, either London or either the London headquarters, or throughout the two universities already recognized to provide such kind of qualification. And absolutely, in case of you would like to become a fellow, the better you should do is to step the going using of the state so of the paths Ciarb suggest in the website. Fortunately for the members, if they would like to become fellows, can choose not only during their performances and the best, not only in using of the headquarters mechanism, but also knocking the door to any of the branches which ables to achieve such kind of formation. As I have already listened to Irina, the UAE branch would give precisely a push on this.
Okay.
And that's all.
Okay, thank you very much, Antonio, and all of you for your answers. And now we are approaching the end of this panel discussion. It was my pleasure to moderate this interesting debate among our panelists. Given the wide-ranging impact of the topics addressed, I'm sure that we will be hearing more as we move forward. We move forward. And now, before we leave, please remember that this recording will be shared on social media in the next few weeks. And for future events from our Iberian chapter, please follow our post on the Ciarb webpage or email us at eventsiberianchapter@gmail.com. I will paste this email in the chat. And last but not least, if you are a Ciarb member with a presence in the Iberian area and would like to get involved, please join us on our private LinkedIn group or send us an email to members Iberian chapter. So I will paste again this email in the chat as well. So we are already preparing, the Iberian chapter is already preparing the agenda for next year with 3 events coming up. So we welcome you to your suggestions anytime. And that will be all on my side. I will give the floor to Antonio for his closing remarks. Antonio, you are muted.
Sorry, third time. Hope I remember. Thank you, Natalia, for leading the conversation and keeping under control the panel. Just last idea. Our next event will convey to a conversation between judicial judges and arbitrators talking each other about how can we deal together. This will be going for the next month, November, the day 14th, and it appears to be an interesting conversation more than discussion, about how to improve arbitral industry among one of our apparently partners, trying to then to get as real collaborators with arbitrators. Now I would like to express my gratitude to all the speakers and the audience. Thus, I just say thank you all in the name of the Iberian chapter of Ciarb for joining us today. And I would like to give the word to Irina to close this event. She deserves it, so by doing this every year. So then, Irina, please close our event of today.
Thank you, Antonio. Thank you very much. Thank you to everyone who stayed with us for over an hour now. Thank you for taking the time today. And of course, huge thanks to Natalia for all her work with this event and for moderating the panel today, and to all of our speakers. That was very insightful to learn about, the practice in Iberia and where connections lie between the two different regions. Look, I think given the topic of today's discussion, which is examining Ciarb connections, so to say, nowadays, I think international arbitration practice and community has never been more globally connected than it is today. There's cross collaboration ongoing at all times. And I guess all of us do realize that somehow the pandemic, of course, fast forwarded many of the, technological advancements that, allow, for example, events such as today to happen. But I think, in the end of the day, the arbitral institutions and also organizations such as the Chartered Institute of Arbitrators is there to serve the users of ADR, which are the clients effectively. And I think it's important that we keep asking ourselves, all the time questions. Do we serve our clients, well enough? What needs to be done to serve them better? What are their needs? Are we able to meet those needs? And in terms of also serving our membership, also how perhaps we can distinguish ourselves as the institute and offer better value for member. So, all of these questions, of course, it is not a one-off exercise. I think it's an ongoing process of improvement. And I think, generally speaking, arbitral institutions are, to my mind, perfectly placed to keep up with the growing demands and changing demands of the global market. And I think they do that. They seek feedback, they revise the rules, something that we discussed earlier today about the recent, new rules, new set of rules for DIAC. Obviously, they try to offer better solutions for administering the cases, more cost-effective solutions for their clients, and also offer better technology and tools, for example, online platforms for case management, which is, I think, it's not only very important, I guess one cannot do without these days. So that's there. And just last few final words about the Institute. I've been involved with a number of activities and in different capacities as well in the last 8 years or so now. And I have to say that I've seen Ciarb really growing from strength to strength. And for example, just last year, we've undertaken significant research, member research, the results of which are still informing the changes that we are doing, the improvements that we are doing internally in terms of, services, procedures, any sort of supporting information that we can provide to our members to support them throughout their careers. There are a couple of reforms that are ongoing internally to that end. One of them is the education and training reform, which is currently on the way, and also a digital infrastructure project is also ongoing. But the most significant, I think, update for me anyway, is the recent introduction of chartered adjudicator status, which is a very fresh, very recent news. And of course, we understand that's still, subject to approvals from Privy Council and also changing the Royal Charter, which might take some time. I think Robert told me probably up to 12 months or so. But we are very hopeful that that comes through. And if that happens, we will be the first and only, for now, professional body that is actually able to award such a status of the chartered adjudicator. So I say, watch the space.
Okay. Robert, I don't know if you want to say something else as for fresh chair.
Thank you, Antonio. Yes. Yeah, thank you to the organisers. Irina, Natalie, you've done a wonderful job, I have to say. A very good seminar, I think. And I think it's been an extremely good event. The panelists have been excellent. Antonio, of course, Pavel, as well as Sam, and hopefully a little contribution from myself, have made this an event that was worthwhile. The Chartered Institute does, of course, go from strength to strength, and it is building. As Irina mentioned, the up-and-coming chartered adjudicator, as long as, of course, is passed by the Privy Council, is going to be something, a step in the right direction. There's also talk of trying to make the chartered mediator. The reason that that's not being pushed forward at the moment is actually down to UK law. The government is looking at mediation in more detail. At the moment, of course, the Chartered Institute has to comply with the UK charity law, and therefore, naturally, they have to hold back mediation as a chartered status. But that will be coming in years to come. And so I can see that this will help the Chartered Institute become more relevant in the world and hopefully continue to grow. And one thing I would say to everybody is still out there is if you do have any particular questions, we weren't able to answer all the questions I noticed on the chat. Certainly I would be happy to answer them if you want to either pick up the phone or indeed email me. So good luck to everybody. Those who wish to become arbitrators, it's a hard road, but it's worthwhile once you get there. But you do need experience, of course, to be able to be an arbitrator and a good knowledge. And we do give that training. So thank you very much to everybody. What a wonderful event.
Thank you, Robert. So then, bye to all. Success and goals achieved. Thank you. Thank you to all. Bye.
Thank you very much.
Thank you. Bye.
Thank you. Bye.
Thank you. Goodbye.